General.
Does Montana have, I mean, it seems to me that there's some confusion in the case law, and I mean, I think there was some sloppiness in the standard in this case. Does Montana have some separate community caretaker exception or something that it calls a community caretaker exception that's really equivalent to our emergency aid section from Brigham City?
Yes, Justice Barrett. I think that's when the Montana Supreme Court discusses the community caretaking exception, I think they're folding in Brigham City. There was some confusion, I agree, in the standard, but it's an exigent circumstance exception to save human life, and I think that's essentially what they did. Okay, I mean, they're free to call it, as a matter of state law, I guess, whatever they want to call it, but you would agree that there is no such strand, that we've rejected that. We've rejected it in Cornelia. It's been a long day. But that the emergency aid exception and the standard from Brigham City is all you're asking for, and you're not saying that there's some yet another looser standard. That's correct. We are entirely consistent with Brigham City and Caniglia. We're not asking for anything beyond that.
And on that
point, I'm sorry, and their citation to Loveland we just ignore, where they said it was less than reasonable suspicion?
Well, the court is admittedly using imprecise language. What I think is what's important is that the court is applying the totality of the circumstances, and it's making sure the scope and manner of the search is reasonable. And of course, as my friend was up here and the court was asking questions, pointed out that the court does use some language mirroring at times in sort of the more specific application of the test that mirrors reasonable suspicion. But this court has done that in TLO and the special needs cases. And so what the court is looking to do is make sure that the scope and manner of the search are reasonable and balancing the privacy interest at stake.